They say they find a loophole in Lil Durk case for him to come home. Let's see what they talking about.
So I see a bunch of people online saying that Lil Durk is about to come home because his lawyers found a loophole. And because of this loophole, Lil Durk is going to have to get set free. Right. So I want to dive in to what everybody's talking about and explain to y'all what's really going on. Right. First off, let me say Lil Durk ain't coming home. All right. I don't know who told y'all that, but that is definitely not happening. But all of this news basically came from two motions that were just filed by Lil Durk's attorneys. One is a motion to dismiss because his attorneys say that the indictment that was passed down was too vague, or if not dismissal for the vagueness, they're requesting that the government provide a bill of particulars. All right, so in this first motion, Lil Durk's lawyers are arguing that the government has hid under a veil of vagueness in order to keep Lil Durk locked up because they don't have sufficient evidence. That's what his lawyers say. They're basically saying that the indictment doesn't explain the details, right? They accuse Lil Durk of putting a hit on Quando Rondo. They accuse Lil Durk of paying and sending people to LA to execute that hit, resulting in the death of Lil Pab. But his lawyers are arguing that the indictment doesn't include exact words that Lil Durk used to make this offer. All they put in their indictment was that he sent a message saying, you know, don't book no hotels or flights using my credit cards. In the indictment, they don't say when or where he supposedly said that he was going to pay to have Quando Rondo shot. In the indictment, they don't say what was actually promised, and they really don't say who received those directions. Because of that, his defense is saying that the indictment violates his 5th and 6th Amendment rights, which guarantee that a defendant has to be told the exact nature of the accusations against him so that they can defend themselves. So they're asking the judge to either throw it out, dismiss it, or force the government to hand over this bill of particulars, laying out all of the actual evidence they have against Durk, right? The second motion was also a motion to dismiss, but it was also a motion to disqualify the prosecutor himself, as they say that he has an unlawful designation as the prosecutor, right? So they're calling into question the legitimacy of the prosecutor himself. That's what we've got going on. And the prosecutor's name, who they're talking about, is Bilal A. Asali, I believe is how you say his name, but they're saying that he was made the interim U.S. attorney by the Attorney General in April of 2025. That was a temporary authority that expired after 120 days, unless the President Trump, nominated and the Senate confirmed this new person, or unless the local federal judges officially reappoint him. The 128 days for his temporary authority ran out in July of 2025, and none of those things happened. Instead, the Trump administration allegedly used a backdoor trick to keep him in charge by reappointing him through legal technicalities. First, by naming him the special attorney, then the first assistant, then calling him the acting U.S. attorney. And Lil Durk's team says that violates the appointment clause, or Article 2 of the Constitution, and also the appropriations clause, because he's using federal money with authority to do so. That's what we're going to be looking at. Let's go ahead and jump into the paperwork, which is where they're calling the vagueness of the original indictment. And they say this indictment is impermissibly vague. It leaves the defense to guess as to the government's theory of guilt, and it leaves the government free to change that theory as its cooperator stories morph over time to meet the demands of a conviction. Because the indictment omits the factual particulars necessary to give Mr. Banks notice of the charges against him and to permit him to prepare his defense at trial, it fails to satisfy this section in his 5th and 6th Amendment rights. Dismissal is warranted, they say. As an alternative to dismissal, the motion seeks a bill of particulars under Federal R Criminal P7F along with the 5th and 6th Amendments. Counts 1 and 2 allege that Mr. Banks conspired to and participated in murder for hire, or in other words, a murder as consideration for the receipt of and consideration for the promise and agreement to pay anything of pecuniary value, or what the government has called a bounty. It says the problem with counts 1 and 2 is that while they do allege in general terms that Lil Durk offered a bounty for Taekwon Bowman's murder, they do not provide the specifics necessary for him to adequately prepare his defense, to prevent surprise at trial, to protect against double jeopardy, or to prevent the government from shifting its legal theory or straying from its grand jury presentation. So basically what they're saying is the indictment didn't tell us enough for us to be able to properly defend him. And also, because of the vagueness, if details are changing as this case is developing, we have no way of knowing because we don't know the details, right? And that does make sense. It says the indictment only alleges that Mr. Banks used unspecified coded language that made clear that Taekwon Bowman's killer would be rewarded with money or lucrative music opportunities with OTF. But according to the government, what was the coded language he used upon which the grand jury based its charging decision? When, where, and how was the coded language bounty allegedly conveyed? What were the monetary rewards and the music opportunities that were supposedly promised or delivered as consideration for the murder? Without more, there is a real danger of a constructive amendment or a fatal variance at trial in violation of the Constitution. A similar deficiency plagues the "at the direction of" language that affects every count of the indictment. While the indictment alleges that the co-conspirators carried out various acts at the discretion of Mr. Banks, like flying to Los Angeles, tracking, stalking, and attempting to kill Taekwon Bowman by gunfire, and procuring firearms and equipment used to do so, it fails to give any specifics. The whens, wheres, hows, and the whoms did Mr. Banks give these alleged directions? To ensure basic fairness of the trial, the defense is entitled to know, and they're right, they are entitled to know. It says, given the vagueness of the indictment's bounty and the "at the direction of" allegations, if the indictment is permitted to stand, a bill of particulars is warranted. Mr. Banks, Lil Durk, requests a bill of particulars that reflects the theory upon which the grand jury rested its charging decision, and that gives Lil Durk fair notice of the allegations against him. Specifically, we request the following information. 1, the language that Mr. Banks allegedly used to convey his offer, the nature of the item of pecuniary value or the monetary reward or music opportunity that Lil Durk is alleged to have offered, the date, time, audience, and circumstances of the alleged bounty offer, and the language used, the date, time, audience, and circumstances related to the "at the direction of" allegations in the indictment. This request is made under Federal Rule of Criminal Procedure 7F in the 5th and 6th Amendments. Right now, the Lil Durk indictment is something I've covered on my channel a million times. I have told the story so many fucking times that I'm not going to do it again in this video, right? But that basically sums up what this motion right here is. And I'm going to tell you why this motion to dismiss isn't going to work, because why would they dismiss it if they could just hand over the evidence, right? Like, they're about ready to go to trial. I'm sure that they don't mind giving the particulars over, and I'm sure that a judge is going to read this, and he's definitely not going to dismiss murder charges because he feels like the indictment was vague. He's 100% going to, if anything, either dismiss this entire motion or approve the part for a bill of particulars. All right, this right here is not going to get Lil Durk set free, right? Which brings us into the next one. This is the one where everybody is saying that, oh, they found a loophole. This loophole is going to allow Lil Durk to walk free because they're saying that the prosecutor on the case has an unlawful designation and he shouldn't be the prosecutor in the first place. And they're basically saying, again, because his spot is unlawful, that him spending money on this case, people working for him, it's just not legal. That's the argument, right? So it says designation of Bilal A. Asali as the U.S. Attorney for the Central District of California violates the Appointments Clause of the United States Constitution. The Appointments Clause does not permit the Attorney General to appoint, without Senate confirmation, a private citizen and like-minded political ally to wield the prosecutorial power of the United States. As such, Mr. Asali lacks the authority to conduct this prosecution, which can be taken only by someone lawfully appointed as a federal officer. Because he is not lawfully appointed, allowing Mr. Asali and the prosecutors he supervises to continue federal spending in furtherance of this prosecution also violates the Appropriations Clause, which prohibits the payment of Treasury money unless it has been appropriated by an act of Congress. Mr. Asali's lack of authority to conduct this prosecution or expand the funds necessary for this prosecution requires that the second superseding indictment be dismissed and that Asalee and all attorneys in the office be disqualified from participating in this prosecution. It says Martin Estrada, the most recent Senate-confirmed U.S. attorney for the Central District of California, resigned on January 17, 2024. From that date until April 1st, then First Assistant Joseph McNally served as acting U.S. attorney. Effective April 2nd, the Attorney General appointed B. Law as interim U.S. attorney under 28 U.S.C. 546A. The president did not submit Mr. Asalee as a nominee for Senate confirmation, and under 546C2, his service expired after 120 days of 2025.
Okay.
Judges of the district declined to make an appointment.
Pause that for y'all.
The Central District of California resigned on January 17, 2024. From that date until April 1st, then First Assistant Joseph McNally served as acting U.S. attorney. Effective April 2nd, the Attorney General appointed B. Law as interim U.S. attorney under 28 U.S.C. 546A. The president did not submit Mr. Asalee as a nominee for Senate confirmation, and under 546C2, his service expired after 120 days on July 30th, 2025. Public reports indicated that judges of the district declined to make an appointment under 546D, but there was no order or announcement. With similar expiration dates looming in this and at least 4 other judicial districts, Mr. Asalee disclosed in an interview that his service might continue. Some tricks up our sleeves for allies, then began to describe acting United States attorney. This was in fact a trick because it circumvented limitations that Congress temporary service in important federal offices like the U.S. Attorney's Office. The trick involved a 4-step on July 29th, the day before the expiration of Asalee's 120-day term limit. First, the Attorney General appointed by Asalee as a special attorney, citing the authority vested in the Attorney General by law. Second, the Attorney General appointed Mr. Asalee as first assistant for the attorney of the Central District of California, quote, effective upon his resignation as United States attorney. Third, Mr. Asalee purported to resign my position as interim United States attorney for the Central District of California. Yet, in the very next and only other sentence of his resignation letter, he announced that he looks forward to continuing to lead the U.S. Attorney's Office for the Central District of California. And then fourth, the Attorney General ordered that as first assistant, Mr. Asalee will have authority to serve as acting United States attorney upon a vacancy in that office, subject to the conditions and limitations of the Federal Vacancy Reform Act of 1999. It says, because Mr. Asalee is not validly serving as the acting U.S. attorney, the court should apply appropriate remedies to address his unlawful actions, supervision, and expenditures. In addition to any other relief the court thinks proper, it should void the indictment and dismiss it with prejudice, or in the alternative, without prejudice. It should also disqualify Mr. Asalee from participating in this criminal prosecution, along with any attorneys acting under his supervision or paid with funds from Mr. Asalee that was not authorized to expend. All right, so it's simple. They're claiming that this dude was never confirmed by Senate. His 120-day interim term expired in July of 2025, and they say that the Trump administration basically kept him in charge anyways using a trick. Now, before I talk about why this won't work, let's talk about why it could work, right? There are similar challenges happening right now in other districts. In this motion, Durk's attorneys cite those similar situations, like United States versus Gerard, United States versus Salazar, and other cases where defendants have already argued that Trump's Justice Department illegally kept unconfirmed appointees running federal office. In some of those cases, judges have agreed enough to hold hearings, and at least 2 courts have issued rulings disqualifying those U.S. acting attorneys. So this isn't like a random conspiracy theory. It's an actual constitutional dispute that is going to move through the courts. There have been cases in the past like NLRB versus SW General and Lucia versus the SEC in 2018, which said that improperly appointed officers can't legally exercise government power, right? Basically saying that if a judge finds Asalee was illegally appointed, then technically he had no power to bring the indictments, meaning every indictment that he signed since his term expired would be invalid. If the judge agrees, the remedy could be serious, right? The court could dismiss Durk's indictment entirely, but they could also just disqualify Asalee from the whole office, forcing the DOJ to lawfully appoint a new prosecutor. The government could then re-indict Durk later, but it would buy him some time. It could possibly get him released temporarily, but let's talk about why it probably won't work, right? Courts prefer to fix procedural defects, not nuke cases, right? If the judge finds that Asalee was unlawfully appointed, they might just say, okay, so he can't continue on the case. We're going to assign a proper U.S. attorney and move forward. Basically, they can cure the defect in this case without freeing the defendant and nuking their entire case. There is a long-standing rule called the de facto officer doctrine that says that even if an official was improperly appointed, the acts that they took before being challenged are usually still valid, right? This doctrine was created to avoid this specific type of chaos. So even if Asalee shouldn't be in the job, the court still could decide that his indictments stand, right? At the end of the day, Durk's attorneys are challenging the Department of Justice, and the Department of Justice has backup authority. The Attorney General can reauthorize another official to take over prosecutions. They can even argue that even if Asalee's title was invalid, someone else had legal authority to sign or supervise his case, right? Courts don't like gotcha moments in dismissals in serious cases, especially cases that are murder for hire or organized crime cases. Judges are going to be hesitant to let someone walk over a technicality unless the entire process was fundamentally unconstitutional. The most likely situation for this is that the motion is going to be denied, right? They're probably just going to say that even if Asalee's appointment wasn't legal, that it's not going to invalidate Durk's case. And if that happens, everything will proceed normally. They could get a partial win here, which is where the court can agree that he wasn't lawfully appointed and they could remove him from office and the case. But the DOJ could simply assign a new prosecutor and possibly just refile the paperwork. The case would effectively be delayed, but it wouldn't be dead. They could get a big win, which is dismissal without prejudice, right? And that's the courts tossing out the indictment completely. But again, the government can just re-indict him under a properly appointed prosecutor. If that happens, then he could be released temporarily, but most certainly he'll be recharged, right? And then there's the nuclear option, which is dismissal with prejudice, and that would be the court throwing this entire thing out permanently, meaning no refiling. And I'm gonna be real with y'all, that's extremely rare and would require proof of bad faith or deliberate constitutional violations, right? But that's what we got. That's the situation. I'm gonna keep it real, man. Durk ain't coming home because of this. It's not gonna happen. You know, I see people saying that is what's gonna happen, but it's not. Mark my words. Come back to this video in a couple weeks. Y'all will see what I'm saying. But that's what I got for y'all. Y'all let me know what y'all think about this in the comments down below. Don't forget to hit the like button, subscribe, tap the notification bell so you get notified every time I upload a video. And as always,
what y'all think? I think you fried. There really ain't no loophole. They ain't gonna get him out. They just gonna delay the case. That's it. But anyway, like, comment, subscribe. I'm out.